Okay. Hopefully everyone, now that it's being recorded, can everyone see the right screen, all that? We looking good?
Yeah.
Okay. So thank you all for being here. Rio and I are excited to be here. I've presented a few times to the chamber. I think this is Rio's first foray into the group, but looking forward to a fun, engaging organization and kind of good conversation about things we're going to discuss. So we've isolated what we see as the biggest big picture things going on in the world of California employment law. Obviously, we could spend all day talking about all the various different updates and what's going on and what we're seeing and what our crystal ball says into the future, but we have an hour, so we're going to spend an hour. And so what we've done is we've isolated three main groups of information that we think are worth discussing as a group. With that said, though, don't be shy about questions. We're here to talk about anything you want to talk about. We can go down any rabbit hole you see fit. We'll bring it back as necessary to the overarching discussion. But ultimately, this is your time to ask questions, to learn whatever it is you want to learn. So the main topics we're going to discuss, just so you have an idea, Rio's going to talk to you for the first half or so of our portion. Is going to talk to you about wage and hour updates. So the various different cases and statutory laws we've seen in wage and hour. Then I'll take over. I'm going to jump in and talk to you about COVID and all of the things that we don't know and some of the things that we do, but also more importantly with how that plays into remote work and the kind of the new workforce, because things are changing, things have changed, and they're going to continue to change. And I think it's really important that we have conversations about that now, so we can make sure that we're best prepared for the future. And then I'm going to wrap things up by talking about arbitration agreements. I know some of you may be saying, well, we don't have arbitration agreements. You should at least be thinking about it. And I think there's some important areas of the law to discuss. And for those of you that do have arbitration agreements in place, really important to talk about, because some of the biggest cases we've seen in the past year have been in that realm. So without further ado, I'm going to keep control because only one of us can do that at a time. But I will turn it over to Rio and I will mute myself. And we will go from there.
Thank you, Ryan. Hi, guys. This is my first time with the chamber, so thank you for having me. As Ryan mentioned, the first kind of topic that we're going to talk about is going to be the wage and hour updates, starting with Penal Code Section 487, Assembly Bill 1003. So prior to January 1, of this year, existing law made wage theft a misdemeanor. So generally, wage theft can occur when employers fail to pay their workers all of the wages that the workers are owed. Some good examples could be things like paying less than minimum wage, failure to pay overtime, requiring employees to work off the clock. However, now this new legislation makes an employer's intentional theft of wages, including tips, punishable as grand theft. So the amount has to be greater than $950 for one employee or $2,350 for two or more employees in any 12-month period. I know this new legislation has probably raised the pulse of any employers here with us today, but I do want to note that under this new law, the wage theft must be intentional. So while we don't have a precise definition of what that's going to look like or how strictly intentional wage theft will be enforced, there is a potential defense of, good faith or honest mistake or clerical error. So do want to keep that in mind. Labor Code Section 90.8, SB 572. So under this statute, the Labor Commissioner no longer needs a final order before filing a real property lien to secure amounts due. Instead, the Labor Commissioner can file a real property lien upon any type of final decision, finding, or even a citation. So it kind of expands the Labor Commissioner's ability to do so. As with other liens on real property, the Commissioner can renew the lien every 10 years until that amount cited plus interest is fully paid. So regardless of whether the Labor Commissioner issues you an order, a citation, or any other type of final decision, you should definitely comply with any such decision to avoid this new type of aggressive collection efforts by the Labor Commissioner. So this slide is pretty self-explanatory and probably known to most of you by this point. However, just to reiterate, the new California state minimum wage for employers with 26 or more employees is now $15 per hour. The salary threshold for exemption purposes in this group is now $62,400. For employers with 25 or fewer employees, the state minimum wage is now $14 per hour, and the salary threshold for this group for exemption purposes is $58,240. Just a little refresher here, exempt employees are employees that are not subject to certain wage and hour laws. Some of you may know there are 3 requirements to determine whether a worker is exempt under California law. One of these 3 requirements is that minimum salary requirement. So that's going to require an exempt employee to be paid a salary that is at least twice the state minimum wage for full-time employment, which are those 2 bullet points reflected in the current slide. All right, Labor Code Section 218.8, SB 727. So this Senate bill added Labor Code Section 218.8, and it extended contractor liability to potentially include penalties, liquidated damages, and interest owed by the subcontractor for certain contracts entered into or after January 1, 2022. So again, this is just kind of expanding or extending the already existing potential liability for contractors. This next section is a little bit more industry specific, but I think it's just important to note regardless. So by way of background, AB 5 was passed in 2019, and it codified what is commonly known as the ABC test to determine if workers are employees or if workers are independent contractors. So this law contains a number of exemptions, and those exemptions allow the common law and more relaxed Borrello test to be used to determine whether a worker is an employee or an independent contractor, instead of that very strict ABC test. So Assembly Bill 1561 extends or further clarifies some of these exemptions. So initially, AB 5 exempted construction, trucking contractors or subcontractors, and licensed manicurists from the ABC test until January 1, 2022. Rather than allow those exemptions to lapse, AB 1561 extends them until January 1, 2025. This Assembly bill also clarifies the exemption for the relationship between data aggregators and those from whom they collect information by providing a specific definition of research subject. And just so you guys understand, what they're describing here are kind of those participant surveys that you may receive through an email or a website. So it's clarifying the definition of a research subject, which is going to be the survey participant. For the insurance industry exemption, this Assembly bill clarifies that the exemption also extends to claims administration and third-party administrator work. Labor Code Section 2783, AB 1506. This bill also extended that AB 5 exemption to apply to newspaper carriers until January 1, 2025, so long as the newspaper distributors provide certain reporting information to the Labor and Workforce Development Agency on an annual basis. Labor Code Section 2699.8 SB 646. This is going to require me to provide a little bit of context as to something called the Private Attorneys General Act, or PAGA. PAGA was enacted back in 2004, and it authorizes aggrieved employees to file lawsuits not only on behalf of themselves, but also on behalf of other employees and on behalf of the state of California in order to recover civil penalties for labor code violations. So under this particular new legislation, janitorial employees are no longer authorized to bring a PAGA action, so long as they're represented by a labor organization and covered by an applicable collective bargaining agreement in effect before July 1 of 2028. All right, class actions. So those of you who are not familiar with class actions, these are typically filed by a single plaintiff, but on behalf of a larger group or class. So the initial step for filing a class action is to file the lawsuit, and then that plaintiff will need to file something called a motion to certify the class. The class has to be certified by the court. In order to do that, the plaintiff has to meet certain requirements. So Castillo v. Bank of America, this case was in federal court. So class certification requirement required plaintiff to satisfy certain federal requirements rather than state requirements. Those requirements are kind of as follows. One, the class has to be so numerous that a joinder of all the members of the potential class would be impractical. There has to be questions of law or fact common to the class. The claims or defenses of the representative plaintiff must be typical of the claims or defenses of the potential class. And the plaintiff must fairly and adequately protect the interests of the class. So the plaintiff in this case claimed that her employer, Bank of America, improperly calculated overtime rate, and the plaintiff sought to certify a class of call center workers. Now, during this relevant time frame, employees of Bank of America in the call center were eligible to receive certain bonuses, but when the employees worked overtime and received a bonus during the same period, Bank of America did make sure to apply that bonus to the employee's straight pay prior to calculating an employee's overtime premiums. So the Court of Appeal in this case held that although the plaintiff was able to establish certain requirements, the plaintiff was unable to establish the predominance requirement because some of the employees were not subject to that Bank of America policy that I just kind of explained, and did not cause injury to all of the employees. For example, employees who did not work overtime or did not earn a bonus during the same period, they're not going to have any claim for compensation based on an allegedly improper method of overtime rate calculation. So the court said, nope, sorry, you didn't meet that requirement, no class certification. Wilson v. La Jolla, here, the trial court declined to certify a class filed by individuals who worked as signature gatherers. So the employer here classified those signature gatherers as independent contractors. Those workers then filed a class action and alleged that they were misclassified and should have been classified and paid as employees rather than independent contractors. With that came many underlying wage and hour claims, such as, failure to provide meal and rest break, failure to provide overtime rate, wages, things of that nature. However, the employer here, La Jolla Group, provided evidence to the court that the signature gatherers were independent contractors. I mean, they had no set work days. They got to choose when and how long to work. They worked in many different areas with many different minimum wage rates. And all of these differences would impact the underlying wage and hour claims. So the trial court determined that the plaintiff had failed to show that there was a common question of factor law that predominated the class. So it's kind of a similar issue as the prior case, but for different reasoning. The Court of Appeal in this case agreed and affirmed the trial court's denial of class certification. Olson v. Lyft. In this action, Olson, the plaintiff, was a driver for Lyft. At the beginning of his employment, he signed an employment agreement that stated he could not bring a PAGA claim in court and required that all disputes with his employer at the time, Lyft, be resolved by binding arbitration. So in response to Olson filing a complaint, Lyft filed a motion to compel arbitration. They said, hey, you signed this agreement. It says you can't bring this claim in court. We got to go to arbitration. But the trial court denied the motion despite the language in the arbitration agreement because California precedent currently holds that PAGA claims are not waivable and are not subject to arbitration. The reasoning behind this is that PAGA claims, unlike private claims brought by private individuals, the individual is not bringing the action on their own behalf in this circumstance. Instead, a PAGA claim is essentially a claim asserted on behalf of the state. And because the state was not a party to the arbitration agreement, the agreements between the employee and the employer, the courts say, no, you can't require that a PAGA claim be arbitrated. So Lyft did end up filing an appeal, but the appellate court affirmed the trial court's decision to deny Lyft's motion to compel arbitration. Bernstein v. Virgin America. So as we've discussed, PAGA allows individuals to sue their employers on behalf of other employees and the state. And they're seeking to recover civil penalties for violations of the labor code in these types of cases. So for labor code sections, a lot of them will have express amounts of penalties specified within the labor code. But for labor code sections where no penalty amount is specified, PAGA establishes a default penalty of $100 for each initial violation, and then $200 for each subsequent violation. And that's per pay period per employee. So you can see how these violations stack up very, very quickly and can lead to high exposure, high liability for employers. However, this Bernstein case affirmed that subsequent violation penalties, so that higher rate of $200, do not accrue until the employer is notified of the prior violations by a court or by a labor commissioner. So that was a big win for employers. Wesson v. Staples. This is another big case for employers. In Wesson, Staples, the employer, moved to strike the plaintiff's PAGA claim. Staples argued that the PAGA claim was completely unmanageable because it would require individualized proof as to each store manager. So for all the Staples stores in California, they were going to have to bring store managers from, to testify as to that specific store. In response, plaintiff asserted that the court lacked authority to decide this. The court instructed plaintiff to provide it with a trial plan so the court could determine if this matter could be efficiently litigated. But plaintiff didn't do that. So instead, in a supplemental brief, the plaintiff agreed that to litigate this matter, Staples would need to provide a store manager by store manager, week by week analysis throughout the entire relevant time period. The parties estimated that they would need a total of 6 trial days per store manager, which translated to a trial lasting 8 years. After that, the trial court determined to strike the PAGA claims as unmanageable. Plaintiff appealed this, and the court appeal agreed with the trial court and concluded that PAGA claims must be manageable, and a court has inherent authority to ensure that PAGA claims can be efficiently tried, and if necessary, they can strike claims that cannot be rendered manageable. So this has, again, been a huge win for employers and can act as a defense to potential PAGA claims. Johnson v. Maxim Healthcare Services. In this case, the Court of Appeal held that an aggrieved employee whose individual claim was time barred still had standing to pursue a PAGA claim on behalf of other allegedly aggrieved employees. However, I do want to bring up certain details of Johnson that point to a much narrower holding. So to have PAGA standing, a plaintiff must have been aggrieved by the alleged violation during a 1-year limitation period, even if they no longer have standing to bring an individual claim. So that's still kind of limiting it. Notably, the court in Johnson did point out that Johnson, at the time of this case, was still an employee of employer Maxim Healthcare and continued to be governed by the terms of the allegedly unlawful agreement. So she was still considered a aggrieved employee during the PAGA 1-year limitation period. So that's a critical fact on this case. Amaro v. Anaheim Arena Management. Some important pieces of guidance from this case. One, the release in any class action settlement should be limited to the factual allegations set forth in the complaint. We've had cases that we mediate, and as part of the negotiations and the settlement, we will work out a deal with plaintiff's counsel where they will actually file a first amended complaint, and they'll add in, any claims that were not part of that original complaint, so long as they're reasonably related to the original allegations, and that can offer some protection. Another important piece of guidance is that a plaintiff may release their PAGA claims outside of the 1-year limitations period of their own claim. All right, regular rate of pay. So some background on this, employers are generally required to pay hourly employees overtime pay, and that pay is at 1 1/2 times their regular rate for all hours worked over 40 in a given work week. So when an employee's compensation consists only of hourly pay, then that overtime rate is going to be easily calculated, right? It's simply going to be 1.5 times the hourly rate. But things get a little bit more complicated when employees receive additional forms of compensation. Because the general rule is that all compensation received by an employee must be included in determining the regular rate of pay. These next few cases are going to help further illustrate that general rule and what it means. The first being Clark v. AMN Services. So here, the Ninth Circuit found that a per diem benefit that the company was paying to its traveling clinicians for expenses incurred while working away from home was actually compensation that needed to be included in the regular rate of pay for purposes of calculating overtime pay. Now, no, this doesn't mean that all per diem benefits need to be included in the regular rate of pay. In this case, the court did determine that because of a couple factors we'll discuss, but ultimately the per diem benefits here were actually more like wages rather than reimbursement for employees for business expenses. So because of that, they needed to be included in the regular rate of pay. And ultimately, the court's decision here turned on how those payments in this situation operated. If a payment varies based on time worked, it's more likely going to function as compensation rather than reimbursement. Now, that's not a determinative, that's not the only determination, but it's one thing to consider. And that was the case here in this case. AMN paid per diem benefits to local clinicians as well, despite the fact that they did not incur travel expenses. So that also led the court to believe that these per diem benefits were more like wages rather than reimbursement for business expenses, and thus needed to be included into the regular rate of pay calculation. Meal and rest periods. So Donahue v. AMN Services, another big case this year. This case established that time rounding for meal breaks is not permitted under California law. This case further holds that there's a rebuttable presumption against an employer if time records show a late, a short, interrupted, or a completely missed meal period. So the ways that a company can rebut that presumption are things like employee testimony, if you have declarations from employees, surveys, statistical analysis. Also, a lot of companies will have employees sign documentation that says, I've reviewed my time, it's all accurate for this week. Farah v. Lowe's, another huge case that deals with regular rate of pay. So since this case came out, California employees are now entitled to premiums for meal, rest, and heat recovery periods at the regular rate of pay rather than their base rate. The base rate was the calculation that was formerly being used by most employers. So this is a huge change for the majority. Even more significant, this ruling is actually retroactive. So employers may now face liability for their previous practices of paying premiums at the base rate of pay. So we have a lot of clients that are kind of doing an audit on their past payments and actually reissuing a payment for those penalties now at that increased regular rate of pay. So, we've been talking about regular rate of pay a lot, and I do want to kind of walk you guys through an example of what that looks like and how it differs from that base rate of pay. So here's an example. Let's say that Bobby is an employee, he's earning $15 an hour, and he works 40 hours in this particular work week. So we're just going to focus on one work week. Let's say that also that week, Bobby earns a $1,000 bonus, which needs to be included in that regular rate of pay. So to determine Bobby's regular rate of pay, we're going to first multiply his $15 per hour by his 40 hours in the week. That's $600. So we then take the $600 and we add his $1,000 bonus and we get $1,600. So again, just looking at that one work week, the total amount of wages that he earned, it's going to be $1,600. Now, to find his regular rate of pay, you're going to take the $1,600 because that's the total wages and divide it by the 40 hours worked because that's the total amount of hours worked, and you get 40. So $40. So if Bobby happened to miss a meal break during that same work week, his premium pay for that meal break is going to be at his regular rate of $40 rather than his hourly pay of $15. So say he didn't get that bonus that week and he's just making his $15 an hour and works that 40 hours a week and he misses a meal break, he's going to get a penalty pay of $15. But because he got that bonus and that increased his regular rate of pay, we're now looking at an increase of $25 to that premium pay. So you can see again how this can really add up quickly for employers. And with that, I will turn this over to Ryan for some COVID-19 updates.
All right, thank you, Rio. So as
question.
Oh yeah, go ahead.
Ria, so the question on the last example you just had, what if you're paying bonuses on a quarterly basis, based on whatever the goals were for the prior quarter? Am I required to include that? Because that could be substantial when you pay it quarter.
Yes. So you're going to have to true up those premium pays based on that quarterly bonus as well, which is a thing that a lot of employers do, right? A lot of employers do end of year bonuses or quarterly bonuses. So a lot of companies are now kind of changing their strategy as to that because of this crazy requirement. And it's, large impact on things like meal break premiums and rest break premiums.
But that would only apply in the week that I'm actually paying that quarterly bonus.
Well, because the bonus is for the entire quarter, I guess I'm just not tracking your question.
It sounds like, I'll jump in. It sounds like, so if it's for the whole quarter, then it would be applied evenly across the quarter. It's not just when the bonus is paid. So the same thing would apply over any period of time. If it's monthly, if it's quarterly, if it's yearly. If this is a problem, and that makes things very complicated, but yes. So the issue then becomes, how do you do that, and with what frequency do you do that? I mean, it's an accounting nightmare because you have to figure out how best to fold this in. But if it is a non-discretionary bonus that's paid automatically based on something, then that would get calculated in. I know that's maddening, but technically that goes into the calculation.
I have no idea how to approach that because everybody gets a different bonus quarterly. So I'm supposed to go back for the quarter that it applied and see if I owe people more money, staff more money based on that quarterly bonus.
Not only do you have to see if you do owe people more money, unfortunately, because you paid them more. And so because you paid them more, the regular rate of pay needs to be adjusted upward for times when they were earning overtime, right? So the thought process behind this, and I agree with you, this is maddening, and it's in practice, all it does is just creates low-hanging fruit for plaintiffs' attorneys to try to latch on. The theory is, okay, you want to take advantage, not you, but a company wants to take advantage of employees by paying them a low hourly rate in overtime. And then really they just back end it all in bonuses. So that way they're not getting paid out really what their fair value is. And it's not being reimbursed over the course of the quarter or the month or the week or whatever.
It really forces employers not to pay any bonuses.
Or not to pay non-discretionary bonuses. Yeah, it's for non-exempt employees, so hourly employees who are eligible for overtime. It makes paying them non-discretionary bonuses extraordinarily difficult, to the point that lots of companies are and will just eliminate that or find different ways to compensate their employees, because it's a difficult math problem, frankly. I mean, there are lots of ways to interpret. We get cases all the time that are regular rate calculation issues, and there's always an argument that it's wrong. We'll do it for employers, and we still have to say the caveat of, look, they could say something else. So sometimes companies will add on. Companies still get sued when they do it right all the time, because there's just one more element in there, one more opportunity for something to be perceived as wrong. It's just like any other cause of action. You could be right, but you're going to pay a lot of money to be right.
Right. Yeah.
It's tough.
Wow. Okay. Thank you.
Yeah.
Sorry
to be the bearer of bad news.
I have a question on that. So end of the year holiday bonuses,
is a discretionary bonus. So that would be the line that we're drawing. You're going to make it discretionary. So then if it's non-discretionary, that's different.
Okay. Thank you.
Now, don't have discretionary bonuses that are non-discretionary by another name. That's different. If you're just saying like, wink, wink, this is discretionary, that's messy, because if it's really automatic, like for example, someone works, if you might have something where someone, if you don't call in sick or if you're not late once over the course of a period, you're getting an automatic bonus. Well, a company might call that then discretionary, but no, it's not discretionary. It's non-discretionary. It's automatic. So don't call something discretionary that is really non-discretionary. Does that make sense?
And then I promise my last question on this issue, because I've had this conversation with some folks, gift cards versus bonuses. Some people are moving to the gift card.
I'll preface this by saying that we are not tax advisors and cannot give tax advice. There may be some tax implications there because you're technically paying, all compensable compensation is subject to taxation. The argument would be it is also compensation and therefore needs to go into that calculation. I'm sorry to share this with you because no one's going to like this. There have been class action lawsuits where there have been companies that have given their employees free food, but then they didn't calculate the value of that free food into their compensation and therefore the regular rate. The argument was that the regular rate compensation was inappropriate. I mean, that's crazy, and there's not law on that narrow issue, at least not that I'm aware of, but technically, if you're compensating someone, that's compensation. Now, from a practical standpoint, companies give people gift cards. That's a thing that happens. So I'm not gonna jump up and down and say stop that, unless you're saying I'm gonna pay half of your compensation this year in gift cards. That's a different conversation, but
Okay.
Yeah.
Thank you.
Cool.
Any
All right,
other
well,
questions before
yeah.
we move to the COVID-19 update? Okay, Ryan, take it away.
All right. Well, thank you, everyone. So I'm going to jump back in. I'm going to give a COVID-19 update. I'm going to talk about those arbitration agreements. And again, we can go on whatever tangents we want. Attorneys, it used to be that, the most common answer you get from an attorney is it depends. It's now becoming increasingly frequent that the answer you get from attorneys as it relates to COVID-19 is I don't know, which is the answer we least like to give as attorneys because we're supposed to know. But there is a whole wide world of COVID-19 stuff that I don't know what's going on. Now, I know I can tell you what the laws are and what they say, but the interpretations are wild, right? So I'm going to start with this probably on most of your radars. We've got the federal ETS, which if you watch the news, you probably saw that, it's blending. I think it was not this past week, but the week before is when the Supreme Court came down with their decision and said that they're not going to enforce the large employer distinction. Now, I keep it on here because it's still kind of flittering out there and it's still floating its way through. It got sent back down to the Court of Appeals. There are things that can still percolate as it stands right now. We have struck down the large employer distinction. Now, if you are a medical healthcare provider, it can still apply to you. I think there may have been one on here. If you have a question, let's talk about that offline, or we can go that way. But suffice to say that what we've seen, the big federal construct doesn't exactly exist right now. But there's still lots of other stuff floating around, and there's lots of stuff that might still come down the pipe. So that's what we're trying to figure out. I put in here a link. So I know this is being recorded, so you'll see this. I'll also make sure that Laura and Elise have a copy of the slides to distribute however you'd like. This is a website that the DIR, so the Department of Industrial Relations, puts together and updates with some frequency. I've got it as a just tab on my favorites list. I think it's a good idea for something to take a look at. And just kind of keep looking, because that's a good resource for California employers, and it gets updated pretty frequently. Because ultimately what we need to do is we need to roll with the punches. We know that things are changing. For example, if we were having this conversation, in fact, we did. I was with all of you, or a portion of you last year when we were talking about COVID supplemental sick pay. Well, right now in California, we don't have a version of that exists right now, but we're probably going to get another, or at least that's kind of the rumor that's out there, is that it's in the works. My guess is we probably will see something, but I don't know. I don't know what it will be. I don't know when it will be. I don't know if it'll be the same, just extended, or if it'll be different. I don't know, but you can keep an eye out for that. You're also going to want to keep an eye out for different changes on as it relates to exclusion and what to do with tested employees or vaccinated employees versus unvaccinated employees, and how long to keep people out of the office. It is a moving target, and you can look at different resources from the states that tell you different things. So I don't have a slide telling you, because I think it's important that you realize that it's kind of an open question, right? And it shouldn't be, but it is, because we've got CDC guidelines, we've got state guidelines, we've got instructions, we've got health orders, we've got OSHA guidelines, we've got Cal OSHA guidelines. Suffice to say that you want to make sure you're keeping track of information and you're erring on the side of more versus less. So generally speaking, now every circumstance is going to be a little different as well. Because there's going to be different circumstances, right? If someone's testing positive versus if they're a close contact, what does that mean? How long are we keeping them out? Are they vaccinated? Are they what we're calling up to date, which means that they're either vaccinated and boosted, or they're vaccinated and not yet eligible for their booster? All of these factors are being thrown out there to go to the idea that typically what needs to happen is if someone tests positive, they isolate for 5 days, and then typically there's another test that will be performed. If it's negative, they can return. Otherwise, they continue the isolation. For close contacts, the rule of thumb is typically around 5 days. There are, for those who are entirely up to date, there can be an argument for less, but typically it's around 5 days to exclude. And then we also want to be keeping in mind our COVID-19 exclusion pay. That is something that does exist. And that's where if someone must include, or excuse me, if an employer must exclude employees with symptoms and from the workplace, and there's a close contact, then you need to ensure that those wages continue to be paid. So if because of they're in contact with someone who's in the workplace and they have to be excluded, you're paying their wages, you're maintaining their tenure, all of that, it remains unchanged. So it's kind of like it's paid leave.
Yeah, but how about, I have a question. Sorry for the interruption.
No, of course. Let's go.
I've got real world examples. My issue comes in that the person is COVID exposed because of a family member not at work, and I have to quarantine them for 5 days, and they have used up all their sick time.
That person, because the contact is with someone outside of the workplace, and you know that to be the case, you're not required to pay exclusion pay for that.
Okay.
They can use their sick time if they so choose, or PTO, or whatever they have, but because the contact was outside, no. Had it been in the workplace, that'd be a different scenario.
Yes, okay.
Okay. A couple of different assembly bills, and by the way, this came into effect on January 15th, a few more rules that we want to make sure we're keeping in mind. Notification, and we have, so notification, that's what's on this slide as well, but this is actually tweaked a little bit. It's now 1 business day. Now, so what we've got is 1 business day to notify individuals of workplace exposure. And it's all employees who are on the premises in the same work site. So it used to be if they it was soft, right? But who's where, if you're nearby, what do you do? Now it's if you're at the same work site, you need to do so within 1 business day. What does this mean for you? You may be thinking, wow, we've dodged the bullets, or we're mostly remote, or we're doing whatever. Great, wonderful. Kudos to you for being the only company in the world that's not had to send out one of those emails, because it happens. Get ready, because ultimately at some point, the statistical likelihood of you having to send that email is pretty high. And what I would rather have is you think about it and you be prepared with it. And it needs to be something that's easily understandable, which is not very difficult to do. There are lots of templates out there. If you need language, I'm happy to send you what we send, because we've had to send a couple. I got a question. So I'll answer that question just 1 second here from Amanda. So, and have it ready, because if and when it happens, what you don't want to be doing is scrambling and trying to figure it out, because all of a sudden your head's spinning and people are making tough decisions. They're trying to figure out what to do and they haven't thought about it. Think about it right now. Okay. Think about it right now. So that way, if and when it happens, you're ready to go. We've got a question from Amanda, I think.
Thank you.
Yeah,
my question kind of piggybacks on the previous question.
Mm-hmm.
So if workers are working from home, designated by management, and they are exposed in the home, how does that work, or how should businesses go about,
That's different. So there's no exclusion pay there. They go to it's the work site. So their work site is their home. So you don't need to notify employees. You don't need to pay exclusion pay if they've been exposed in the home. It's the concept behind exclusion pay is you're coming to work, but you came into work, you were exposed. We have to exclude you from doing work because of something that happened at work, and therefore knocking you out. I mean, I suppose I can imagine a scenario in which someone came to them from work to their home and somehow exposed, but that's pretty limited. Otherwise, no.
Okay.
Same thing for notification purposes. If someone has been working at home exclusively and they test positive, you don't have an affirmative obligation to notify employers or anything, or co-employees or anything like that.
Awesome. Thank you.
Thank you. Okay, one other Senate bill that we've got on here that I want to mention, and really I bring this up more because I think it's important to think about the basis behind it. And it talks about, the violations that can be found against employers the penalties that can be enforced against employers for violations of failing to abide by COVID statutes, right? Because a law isn't really a good law unless it has some teeth. And what we're seeing now is we see Senate Bill 606 that came into effect. I believe this one was on January 1. So it's definitely in effect now. It may have started at the end of last year. In any event, it is in effect now. And it basically gives the state some more authority to look more closely and see if bad things are happening, see if there are enterprise-wide violations, and if so, to kind of throw the book at employers. So there are various things that can be seen as what's called an egregious violation. I've listed them all out here. I'm not going to read them to you, but the concept is basically those employers that are thumbing their nose at the rules, that are saying, you know what, we're not going to do it. We're not going to make our employees do things. We're not going to follow the rules. There's now an opportunity for Cal OSHA to come in and issue citations in a manner that you're not going to like, and to give you egregious violation citations. So all of this is to say, I know that we are all exhausted by all of this. It's been, today's January 20th. So it's been 22 months since all of this began. And now we want it to be done. Unfortunately, it's not done. Our employees want it to be done. Unfortunately, it's not done. So we need to make sure our employees know we're not trying to be mean. We're just trying to follow the law. That's just the way it is. Okay. So, and again, the last thing where Cal OSHA can keep looking. So there are more investigatory powers that now exist for Cal OSHA. So it gives Cal OSHA that opportunity to do it. Don't make your company the one that's a target. That's really the best advice I can give on this is don't get that target on your back. Anytime you have an agency that sees you in their crosshairs, not a great place to be. And I'll tell you candidly, we don't know this for sure, but I believe in my heart that agencies talk to each other. And so when you get one agency that's sniffing around, it's not long before another one is. So the last thing you want is for Cal OSHA to get you in their crosshairs. And next thing you know, the labor commissioner is coming in and they want to take a look at your payroll records or something like that. That's a frustrating place to be. It's an expensive, time-consuming, irritating place to be. Just avoid it. So all of that is a background to what I really want to talk about, which is just how we deal with the new normal. And how we deal with the new normal is that the world is changing, whether we like it or not. And ultimately, if you take a poll, and I stole this, Rio and I have a colleague that gave a presentation on this, and I love these two slides. And so with her permission, I'm using them again. I think they're great, and they're really exemplify what we're dealing with here, which is that people want to work from home. They want to work hybrid or exclusively from home. And then if you ask them why, they give you all sorts of answers. They explain, this is why, this is why, this is why, this is why. And if you look at this chart, there's something really interesting about it. Not one of those top answers is, I'm worried about COVID, right? So now, sure, people are worried about COVID. I'm not here to say that they're not, but the conversation is now shifted. The conversation is shifted towards, we as employees want to be able to have the ability to work from home. We are going to do that. We're going to work for companies that are doing that. What are you as organizations going to do about it? I'm trying to advance my slides here. So I want some things that you want to consider. With the new normal and how this works, you need to be able to work with your employees, because it used to be that we would say that working from home is a privilege, not a right. Well, now, starting on March 20th, 2020, we now know that it is a lot easier to do the things that we thought we couldn't do. That we can have people working from home in a way that we thought we used to not be able to. So now we need to start looking at that possibility. If you haven't, I'm preaching to the choir, but you got to be looking at how you can have hybrid roles. But once you have those hybrid roles or you have people working remotely, now what do we do to make sure we're still playing by the rules? Because all the same rules still apply. There aren't different rules for hybrid employees versus non-hybrid employees. They're all the same. So we need to make sure that we're setting expectations, that we understand how leave works. We're making reimbursement available to our employees. I sat on a panel with an attorney who's a plaintiff's attorney, and we were supposed to kind of be yin to one another's yang. And what he said was, the low-hanging fruit for me right now is reimbursement. I'm going to sue any company who's not reimbursing people from working from home when they have to. So we need to make sure we're making policies like that. We need to make sure we're looking at our meal and rest break policies. We need to make sure we're adequately tracking wages and overtime. It's a lot harder to know what our employees are doing and when they're working if they're not here. We got to keep an eye on our insurance and our taxes. Sometimes people are going out of state. There are employees that are moving out of state. We got to keep an eye on that because there are direct implications for workers' compensation, tax liability, all of that. I put on the slides lots of things we want to consider. I'm not going to go through each of them because I want to make sure we have time for questions, but excuse me, ultimately, there are a lot of things that we want to try to consider. One is the location of where their work is. This is an interesting concept we're seeing now, which is if someone works from home every day and occasionally has to go into the office, where is their primary place of work? It might be their home. And if it's their home, do they need to get paid for travel time to go to the office once a week? Maybe. So if that's the case, why don't we define it the way we want it to be? We define their workplace is still the office, but we're permitting people to work. Call it what you need it to be. Make sure it's something that makes sense and jives with what is consistent. If they're coming in once a year, you're going to have a harder time saying that makes sense, but consider it. Consider what you're going to do about schedules, what you're going to do about when people need to come. There's still meetings. You may need to have days where you set where everyone comes in. For example, you may have certain departments where we say, okay, every Tuesday and Thursday, we need you all to come into the office because there's value in that. Decide what that is. Make sure you have those reimbursements lined up. I already talked about that. And then a lot of the rest is setting expectations. So that often comes in communications. Are we going to have our Zoom screens on when we're talking? How often are we going to touch base? Those sorts of things that we didn't used to have to think about, but there's studies that show they manifestly, or they significantly rather, impact morale, impact employee psyche, all sorts of things like that. So we got to be keeping those things in mind and making sure we're doing what we can to play by the rules, to keep our employees happy and content and all that. And you know what? To keep them away from plaintiff's attorneys who are going to try to pick us off because we got a little lax in our reimbursement or things like that. And then finally, ultimately, you're still paying them to do the same job, right? Whatever your employee is doing, if they're working in the office, they're working at home, they're still doing the same job. So you want to make sure you're explaining that to them. It's not a right to go home and sit at home and sit on Netflix all day. They still need to do the job. So that's where our opportunity as employers is to do that and hold them to that standard and explain to them, look, your job is still X and you're still required to do Y. We expect you to do that. There are some things you can do. There's software that can keep an eye on things. Some employees balk at that a little bit if they realize what's happening. So have a conversation about whether there will be unintended consequences for that. But just set expectations, communicate them, and ensure that everyone is held accountable. That goes a very long way in all of this. Okay, so some things to consider, some food for thought as you deal with your remote/hybrid workforce. I'm sure we may have some questions on that. I'm going to jump though into arbitration agreements, and I'm going to spend, because I want to make sure we have time for questions, about 12:33 now. I'm going to give this another 10 minutes or so we've got questions. As I mentioned in the beginning, I realize that not all of you have arbitration agreements. That's fine, but you should at least be having the conversation about it. Because what's the value in arbitration? Well, technically what an arbitration agreement does is it allows an employee and employer to enter into an agreement whereby they do not, or they agree to keep claims out of court and rather have them overseen and heard by an arbitrator in binding arbitration. The added benefit to employers is that they can make or have their employees in that agreement, whether expressly or tacitly, waive their right to class action. Now, as Rio told you earlier in the colleague case, they can't, as it stands right now, waive the right to PAGA, but we'll talk about that. But that still can be a very valuable arrow in your quiver, so to speak. We want to make sure that you're at least having the conversation about it, if it's something that may fit for you. A couple cases that have come up recently. There was a case, or excuse me, there's a piece of legislation 2 or 3 years ago called AB 51, which said that arbitration agreements cannot be a required component of employment. As in, you can't say, you want to work for us, you got to sign this arbitration agreement. Then it got gummed up in the courts for years. We finally got this Bonta case that came in and said, not exactly that it's completely in effect, but it basically said that it doesn't invalid or that let me think of the best way to say this. It paved the way for AB 51 to be enforceable. What all this means is you should still have language at the bottom of your arbitration agreements, if you have it, that says, I understand that this is not a required component of my job, and I do not need to sign this, in so many words. That way, with Bonta, with its progeny that will be coming down the pipe, you'll be able to stay compliant. But from a practical standpoint, most of your employees are still going to sign arbitration agreements all the same, so you can still get by all the same. Okay, I've got, I think it's 5 more cases, but I'm going to do each of them in a minute or two. They each kind of stand for one proposition. Lang goes to the concept of what goes into an arbitration agreement, and really be careful what you add. So in very brief form, what happened with the Lang arbitration agreement is that it was, quote, permeated with unconscionability. It had language in there where the plaintiff waived punitive damage claims. It reserved different rights that wouldn't normally exist. And so because of that, the court said, you know what, we're going to throw this out. It's permeated with unconscionability. So what that means to you, if you have an arbitration agreement, don't get cute. Use the language that is normal. It's a relatively boilerplate thing. When we write arbitration agreements all the time, they don't vary very much, and they shouldn't. They should be pretty straightforward. They should have what they need to have from a statutory perspective, but we should leave it at that. Because if you get too cute, you might run into the issue that we saw in the Lang court, where Monster Energy got pushed back on because they permeated. It was permeated with unconscionability. Okay. Here's another one where in Garner, it's be careful what you put in the agreement, because what happened is, as I mentioned earlier, we had an arbitration agreement can waive class claims. What this arbitration agreement did is it kind of did the opposite. It said you can put class claims in arbitration. And so because of that, the matter could be compelled to arbitration, but then the class claims can be arbitrated there. That's not great for a few reasons. One of which is that an arbitration an arbitrator's decision generally is not appealable. And because it's not appealable, if something goes the wrong way, there's not much you can do to gum up the works. You know, if you had a class action in Superior Court, very few of them actually get litigated because they take too long, and so they settle. They all do, just about all of them. But if you actually did, and you actually got to a verdict, and it was adverse to you as the employer, candidly, you could appeal it, and you could just gum it up forever. Not forever, but for a very long time. There's benefit to it, because then you go back to the settlement and negotiation rounds, and you see what you can do. So what this case did is it showed, be careful what you put in that agreement, because you might just have to do exactly what you said you wanted to do. Okay. Kali goes to the similar concept that we talked about, or that Rio talked about earlier. You can't compel PAGA claims to litigate to arbitration as it stands right now, because the state's a party. However, there is a case that's currently going to be considered by the United States Supreme Court that's going to look at this. It's called Viking River Cruises. And it looks at the issue of whether or not you actually can. And if that's the case, then what we would be able to do is we can enforce arbitration agreements and waive all representative actions, including PAGA. This is very new. This just happened last week or two. So we're still trying to figure out what exactly to do, because the Supreme Court hasn't yet issued a ruling. So we don't know if it's going to help us or just maintain the status quo. But there are a lot of defense attorneys percolating on what we're going to try to do with this to try to use it to our advantage. So that's something that we want to make sure we consider. 2 more cases I want to talk about. One is Jarbo. Jarbo deals with the concept. The way it would typically work is if an employee has an individual claim and a PAGA claim, they would file that and we would compel it to arbitration. We would say, okay, we know that we can't waive the arbitration claim, but what we can do is we can ask to stay the arbitration claim in regular Superior Court and just litigate the arbitrable, so the individual claim individually. And from a practical standpoint, what that does is it slows things down, and we're able to try to just negotiate a settlement of everything rather than having to litigate the PAGA claim at the same time. Jarbo says, no, there's not an automatic stay. And in fact, these things can go at the same time. So when we ask this of plaintiffs, we get Jarbo thrown back in our face. They say, we're going to litigate dual chamber. We're going to have an individual arbitration. We're going to have the PAGA claim in Superior Court, and you better hustle. So that's one that's not great for us. And then I'll end it with one more that's narrow, but also not great for us. And that talks about when you need to compel arbitration. And in short form, in Fleming, there was arbitrable claim, but it proceeded through the labor commissioner through the end. And then the defendant raised the issue and said, oh, we need to go to arbitration. Too late. So the point of this, or the reminder from this, is that if you have an arbitration agreement and you have a claim that's been levied against you, you need to move to compel arbitration basically immediately. It's the concept that comes in is you waive your right if you don't do it by the time you avail yourself of the court. So if it's filed in superior court, you might be able to file an answer, but if you start actually litigating the case and actually doing things before the court, that's not enough. So that's where we stand on this. If you have an arbitration agreement, make sure that you're enforcing it. If you want to, that you're doing it quickly, you're having that conversation with your counsel quickly, so that way you can ensure that you are getting the benefit of the bargain into which you enter. Okay, that was rapid fire, but we had a lot to cover. It is 12:40 here, so we've got some time. If anybody has questions, we are here, whether on things we've discussed or anything else.
Questions for Rio or Ryan? Fred, I know you had some questions.